to their employees. Hi guys, Matt from VShore here. Just thought I'd take a moment of your time to talk about Single Touch Payroll and the implications that maybe you hadn't considered yet. Single Touch Payroll, you'd be fully aware of right now. It comes into effect on the 1st of July 2018. If you're not familiar with it, it's new legislation that requires any employer with 20 or more staff to report to the ATO on their pay cycle what they're paying to their employees, and continue to do that throughout the financial year. So let's just take a step back and consider why the ATO is moving to effectively real-time reporting around payroll. So without Single Touch Payroll, the ATO has had no timely transparency over how much employees are being paid, what superannuation contributions should be being paid, or even who is an active worker within each organisation across Australia. Historically, it's taken the end of financial year payment summaries in order for the ATO to collect that information. And effectively, they're getting it in retrospect. They're getting it after the year has been complete, and they're relying on effectively the information the employers are sending in July in order to work out what's transpired across the year. What is now going to happen from the 1st of July this year is that the ATO is going to start getting timely transparency over such things as how much employees are being paid, what superannuation should be being paid, and who is an active worker in Australia at any point in time. The ATO has also come out very importantly and said that it's going to share that data using what they call the data sharing program. The data sharing program has specifically identified 3 departments that they're really looking to work with to share this data to enforce compliance across various different agencies. Obviously, is Centrelink. We shouldn't be too surprised about this. The government is going to be able to cross-match who's being paid benefits versus who's being paid through employers on a real-time basis rather than after the end of financial year time. So that's a pretty obvious use of the data. The other one is the Department of Human Services, particularly looking at child support payments, and is what's being paid through child support in line with the actual what is being paid by the employers to those who are registered for child support. And the one that's of particular interest to us here at VShore is the Department of Home Affairs, what used to be called the Department of Immigration and Border Protection, now called Department of Home Affairs. But their particular interest is knowing who is an active employee right now, because they haven't ever really had transparency without coming on site and doing an audit, knowing who's being employed either legally or illegally in terms of their work rights and their visa conditions. And so today I'm going to focus particularly on that and why you need to ensure that your current compliance processes around employee work rights is really airtight before you start lodging information to the ATO with the Single Touch Payroll program. So let's focus on what VShore is all about and also what the Department of Home Affairs is going to use this Single Touch Payroll data for. So in 2013, came into effect on the 1st of June 2013, the Migration Amendment Reform of Employer Sanctions Act took effect. And the big piece of that legislation is that there was an obligation on the employers to check and keep checking the work rights of their staff and their contractors. Effectively, the onus of responsibility to ensure that each and every one of the workers is legally allowed to be working the hours in which they are working for that employer has been enforced since June 2013. And there's some pretty hefty penalties for non-compliance. So you can have on-the-spot penalties of $94,500 per incident to an employer and even $18,900 to the individual, be it a director or an officer, who is found to be in breach of the Migration Amendment Act legislation. That is, one of their workers is found to be working outside their work rights. You've seen this growing as a governance issue in Australia since that June 2013 date. There's been news articles and lots of changes from political perspective, I think largely driven through things like Trump and Brexit in the UK. But what we've seen is 457 scheme recently ended. It's a larger focus by the government on enforcing compliance around foreign workers. And really, this Migration Amendment Act 2013 is an overlooked piece of legislation that not many employers have really been complying with. So by law, since 2013, every employer has had the ongoing obligation to monitor their work rights of their employees. But unfortunately for Department of Home Affairs, or immigration as they were once known, they really had little way of enforcing that legislation. Yes, there was a thing called Task Force Cadena where they were cooperating with Fair Work, but it meant them sending an officer out to your premises to audit your work rights of each and every one of your employees for them to be able to tell whether you have an active employee that's illegal or not. Now, that was such a burdensome process on such an under-resourced department that you probably haven't heard of too many prosecutions outside of Woolworths recently for their shopping trolley collectors in Tasmania, amongst others. But it's often overlooked because there's really been little to no enforcement. But think of this, from the 1st of July 2018, there's going to be a data sharing program between the ATO and Home Affairs. So they're going to know in real time who is an active worker within your workforce. And interestingly, since December last year, the Department of Home Affairs has been quietly collecting the tax file number of every foreign worker, every visa holder active in the Australian market. Why did they do that? Well, think about it. It gives them that cross-check. Who is an active employee? Who basically has the work rights to be an active employee? Who's exceeding their work rights? Is a student working 40 hours rather than 20 hours inside school terms, etc.? They've never had the transparency over that. They'll now get, through the ATO Single Touch Payroll, access to that information in real time, which means access to en masse real-time audits of the Australian workforce and Australian employers as to their compliance with the Migration Amendment Act 2013. VSure exists to really solve that problem of compliance within your organisation. We're about the work rights monitoring and oversight so that you're finding out about any issues ahead of time before the Department of Home Affairs and the ATO are being able to identify that you've got a problem with any of your staff. So let me just focus on the section of the Act, the 2013 Act that I mentioned. It says here within the Act, 245, capital A, capital B, that an employer must take reasonable steps at reasonable times to verify that a worker is not an unlawful citizen. And it actually prescribes the use of a computer program to do that. And that's VSure down to a T. The law also says that a person may contravene a civil penalty provision without knowing or being reckless. So you don't even have to know about this legislation to actually be fined and have an enforcement order put against you. So ignorance is not a defence. And I've mentioned it before and I'll emphasise it again. An individual director or officer of the organisation can be given an on-the-spot fine of up to $18,900 for each breach. If one worker overstays their visa, one worker who changes their work rights, say a working holiday visa where they're allowed to work 40 hours a week, changes to a student visa where they're only allowed to work 40 hours a fortnight, that problem is the employer's problem. And directors in offices can be directly held accountable, and the organisation can itself be fined $94,500 per worker that's found to be working in breach of their conditions. So how can VSure help you? Well, it's an extremely fast path to compliance. VSure offers bulk uploads from Excel or CSV formats, so we can do an en masse audit of your workforce quickly and easily. We also provide a simple process for data cleansing. Often people don't have the data in the right formats, and VSure acts as a mechanism for being able to cleansing that. We also have a a very mobile-friendly or tablet-friendly wizard where you can take a photo of your staff's passport, and we'll strip the data from that and do a work rights check against them. So if you've been a bit lax in your work rights compliance, just get the staff to bring in their proof of work rights, i.e. an Australian birth certificate, Australian citizenship certificate, an Australian passport, a New Zealand passport, or a foreign passport, and then a visa entitlement verification online check must be performed. VSure automates that process for you. We have this nice little mobile or tablet optimized app where you run through and take a quick snapshot of the passport, and then we will basically do the rest from there. We'll then provide ongoing monitoring of those work rights. So we'll check and keep checking those work rights throughout the term of employment. And we'll send you a notification via email or SMS whenever there's anything that's happened. The other thing we do is we also provide a plain English definition of what the work rights restrictions are. You may have done Vivo checks before and you've seen codes like this one, 8547. What does 8547 mean? So you go elsewhere to try and find out what the work visa condition 8547 means. Well, in VSure, you never have to do that again because we provide that plain English definition of any work entitlement or work restrictions, not just the codes. And as I said, in the automation of the ongoing checking, we're just going to push you an SMS or an email that says, hey, we've done the checks for you. Hey, we've identified a couple of issues. You need to click on this link to log in and find, is there some employees whose visa statuses have changed? Are there some employees who are coming up for expiries, etc.? We just automate that process. So rather than having to check every employee every month or 2 months or whatever cycle that you deem to be reasonable steps at reasonable times, this system can automate it. We recommend monthly to do those checks for you, and then you only have to deal with the exceptions, which might be, as I said, those coming up for expiry or those who have changed visas, such as they've moved from a working holiday visa to a student visa, etc. So in a nutshell, with Single Touch Payroll upon us, there's never been a more important time for you to get on top of your work rights compliance. If any of this scared you, or if any of this basically resonated with you and you want to find out a bit more about VSure, or if you're looking to do an audit of your existing workforce, please reach out to us today, vsure.com.au, and we'll be more than happy to help.